All
Well,
right,
good.
everyone. Oh,
Thank you.
sorry about that, Melly. Yeah, just welcome everybody to this Mid-Atlantic Resiliency Link virtual town hall. Really appreciate everyone for joining us, especially everyone at the Hayden Town Fire Department. Thank you for tuning in. Just as a heads up, before we get started, any time if you have any questions, there's a chat feature in Teams. Feel free to type it in there after the presentation. We can ask that question. I'll read it out for whoever needs to hear it, whether it be either of the representatives or Melanie with the Office of Consumer Advocate. So without any further ado, I'm going to turn it over to Representative Grimm-Krupa, who is one of our hosts tonight. Take it away, Representative.
Thank you, Jake. And I just want to say first, thank you to Melanie, the Deputy Consumer Advocate, for making her time available and sharing her expertise tonight. Thank you to Representative Cook. We are in session in Harrisburg. That's why we're not there personally. It's been a long day, but I know it was important to both Representative Cook and I to have this so we can get this information out to our constituents as early as possible. Thank you to all the staff members who are working after their normal hours to help make sure this goes on hopefully seamlessly. And thank you to everybody that's participating. If this town hall is going to be specifically focused on filing protests and petitions to intervene and public comments. We did have a really great town hall with the consumer advocate, Daryl Lawrence, as well. And that presentation is available on my website, on our social media, and I believe the Office of Consumer Advocate, their website as well. But before I hand it over to Mel, I believe Representative Cook has some welcoming remarks as well. Thank you.
To find the right button to push will be good. Mel, thank you so much. We really appreciate you coming on board. All our support staff here in Harrisburg and out there. It's just very, very, very important, I know, to us that you get the information that you need, and that we're very grateful that we can provide that to you. So, we get Q&A, and even after the meeting, please feel free to reach out. Again, thanks for everybody. Thank you so much. We really appreciate.
So, Melanie, if you're ready to take it away, go right ahead.
Thank you very much. Good evening. My name is Melanie Joy Alatia. I go by Mel. I'm the Deputy Consumer Advocate at the Pennsylvania Office of Consumer Advocate. I want to thank Representative Krupa of the 51st Legislative District and her staff for hosting this event, as well as Representative Cook of the 50th Legislative District for hosting this informational town hall. This presentation was prepared by the Office of Consumer Advocate and is intended to be informational as part of consumer education. And if there are many slides, I'm going to be skipping forward to some parts that we think are maybe highly relevant and wanting to, make best use of everyone's time. So, but if you have any questions, I'm happy to take them. I know the initial presenter, Jake, said you could put them in the chat, and I'm happy to answer any questions you have. And my contact or our contact information will be at the end of this slide, and the last slide at the end of this presentation. And so you can always contact us after tonight if that works as well. So again, my name is Mel Alatia. Our agenda today is we're going to talk a little bit about who the OCA is, the Office of Consumer Advocate, a little bit about the Public Utility Commission, or the PUC, the OCA's role in transmission line cases before the PUC, the applications of NextEra Energy Transmission Mid-Atlantic, Inc., or they go by NEAT MA, relating to the Mid-Atlantic Resiliency Link project, or the MARL project. Fifth, your options to participate in the process before the PUC. And if you decide to become a party, the overview of the PUC process. And then in this slide deck, there are some relevant statutes and regulations to assist you, but there probably won't be time for me to go through that tonight, again, unless there's a question. And as Representative Krupa stated, this presentation will be available on the OCA's website for a few weeks, and it has actually replaced the presentation that consumer advocate Daryl Lawrence gave in February, only because it contains more recent up-to-date information relating to the specific applications filed by NEAT MA before the PUC. So just a couple disclaimers. Any opinions that are expressed by me are my own opinions and not the official opinion of the consumer advocate. And any information contained in this presentation should not be construed as legal advice. So about the Pennsylvania OCA. The OCA is an independent state agency created by the General Assembly in 1976 to give the everyday consumer a voice in public utility regulation. Sometimes when I'm trying to speak to new lawyers who might want to work for our agency, I give the reference of David and Goliath in the sense that the utilities, are very large companies, often tend to be well represented by counsel, and whereas the everyday consumer, just living your life, it can be hard sometimes, given all the very technical nature of the utility industry, to be able to have an adequate representation in all things relating to utility regulation. So that is the purpose of the OCA. We are the, technical experts, the lawyers with expertise to be there in all matters relating to utility regulation, to give that everyday consumer a voice. And it's really to keep utility service affordable, reliable, reasonable, and safe, given that utility service is a natural monopoly and is a necessary service in our everyday lives. So just jumping ahead, the consumer advocate currently is Daryl Lawrence, and he was nominated to the role of consumer advocate in February 2025 by Attorney General Dave Sunday, and the Pennsylvania Senate unanimously confirmed the nomination in June 2025. Jumping ahead, skip to the applications of Nextera, and I did say we were going to speak a little bit more about the OCA. Sorry, let me just back up a little bit. I apologize. So the OCA, what we do is we represent and advocate for the interests of PA utility consumers before the following bodies: the Public Utility Commission, the Federal Energy Regulatory Commission, or FERC, PJM Interconnection, LLC, PJM. You're going to hear a little bit about this in the middle of my presentation. And we also represent consumers in state and federal courts relating to utility regulation. So again, as I said, we're a team of advocates that consists of professional attorneys, paralegals, subject matter experts like economists, accountants. We have call center professionals, and we have our leadership. And I spoke about consumer advocate Daryl Lawrence, and his responsibilities, his core responsibilities, are to represent the interests of utility consumers, and this is by statute, in front of the PUC, in front of courts, in front of FERC. He is to determine the interests of consumers and if and how to advocate for those interests in any proceeding. And when he does that, he is to consider the public interests, the resources available, and the substantiality of the effect of the proceeding on the interests of consumers. And we have basically our four utility industries that we tend to be involved in, which is electric, five, I guess: electric, water, wastewater, telephone, and natural gas. So about the PUC, two different agencies. So the PUC is the agency that oversees and regulates public utilities. It's the entity, the state agency, that provides due process for interested parties who are concerned with and who are challenging a public utilities filing. And it is comprised of 5 commissioners that are appointed by the governor and subject to confirmation by the Pennsylvania Senate. And the current city commissioners are pictured here. So the main difference between our office and the PUC is that the PUC is the adjudicator. It's the one that makes the decisions, while the OCA is an advocate. We are in there to advocate for the interest of consumers. So Just quickly and at a high level, because we will revisit this slide later in my presentation. Just think there's an initial action, meaning there's a filing by a public utility. There's a response. Our office will look at that filing and decide whether or not we're going to respond to it. Then there's a process, and that's provided by the PUC. And then there's a result, and that is a result of the PUC. The PUC makes a determination after the responses in the full process, and they decide whether or not that utilities filing will be approved as filed or as modified, or if it should be rejected. So our role in transmission line cases before the PUC is, and I think this is going to come up for especially this type of case, is for transmission line siting cases where there are impacted landowners or tenants and occupants. And we just like to caution that clearly we're not anyone's private attorney, but we can help through consumer education. And some of these points here on this slide, I'm going to go through later on in more depth. So now we're back to the applications of NEET MA relating to the Morrow project before the PUC. There are 2 applications currently before the PUC. There's a certificate of public convenience application, and that's at this docket ending in 0921. And there is a transmission line siting application, and that's at the docket number ending in 0856. So 2 separate applications, but they are related. So just to go over this CPC application, this is where NEET MA is requesting the PUC to grant it authority to be a public utility within the Commonwealth. And so they're looking to begin service, and that's transmission service, as a public utility within Greene County and Fayette County of Pennsylvania. They're also requesting in that application approval of certain affiliated interest agreements that would permit NEET MA to receive support services and construction services from its affiliated entities. So this application was filed on March 3rd. It was published in the Pennsylvania Bulletin over this past weekend on March 21st, and protests and petitions to intervene are due May 1st, 2026. Again, the docket numbers are here on this slide. So the second application is NEET MA's siting application. And this is where it is requesting PUC authorization to site a 500 kilovolt or KV transmission line. These are public utility facilities associated with the Morrow project. And they're seeking siting authority in Dunkard Township, Greene County, and Spring Hill Township, Fayette County. Like the CPC application, it was filed on March 3rd and published in the bulletin on March 21st. And like the CPC application, protests and petitions to intervene are due May 1st, 2026. So what's bringing about these 2 applications? The underlying basis for both applications are decisions that PJM has made. PJM in 2022 had an RTEP, a regional transmission expansion plan, that in it determined needs for the bulk electric system relating to reliability. And that particular RTEP determined a need to address significant and widespread reliability criteria violations within the PJM region. And it determined that these violations were occurring or to occur based on anticipated load growth and generation resource retirements within the PJM region. To address it, it sought competitive proposals from transmission owners for transmission solutions. And the PJM Board of Managers reviewed those solutions and approved the Morrow project along with others to solve the reliability violations for the interstate transmission system that PJM helps plan. So, okay, what are we talking about here? What is PJM? PJM is a regional transmission organization, or an RTO, that is overseen by FERC. What's FERC? FERC is the federal equivalent of the PUC. Okay, so it oversees interstate transmission utilities, and it oversees wholesale electricity markets. So PJM as an RTO kind of is like an air traffic controller of the regional power grid, and it coordinates the movement of wholesale electricity across 13 states plus DC. And in doing so, it serves 67 plus million people. So while it operates competitive wholesale electricity market and manages the reliability of the interstate transmission grid, it does not own the transmission lines or the generation power plants that it directs. So this map here on the bottom shows that the nation is split into various different RTOs and something similar to RTOs called independent system operators. So Pennsylvania is located within PJM. And so PJM is this entity on an annual basis conducts something called regional transmission expansion planning. And it's on an ongoing basis to look at what are the reliability needs of the bulk electric system within the region. And so it goes through this process, it solicits competitive proposals, and it ends up selecting the projects that it think are the best fit for solving these reliability violations. And then it goes to the Board of Managers and they approve it. And then from there, it goes to FERC for rate approval. So that's a very high level explanation of PJM. But again, I think it's important to understand that that is the underlying basis for both applications. It is PJM's reliability need determination and its project selection of the Marl project that has brought us here to NEAT MA's two application filings before the PUC. So what is the Marl project? It involves the construction of a new 107.5 mile 500 kV transmission line that crosses Maryland, Pennsylvania, West Virginia, and Virginia. So in the siting application, NEAT MA has proposed a preferred route that it has for the Pennsylvania portions of this transmission line, but it has also proposed alternative routes. And it is proposing to construct this line using new rights-of-way, including where possible right-of-way that parallels and abuts existing right-of-way. In its CPC application, NEAT MA does seek the PUC's approval to become a certificated public utility, but unless and until it becomes a certificated public utility, it does not have the power of being a public utility, therefore does not have the power of eminent domain to obtain any right-of-way for the Marl transmission line at this time. So what are the PA portions of this Marl project? Again, I said it was a 107.5 mile line. Only about 10.7 miles of that will be in Pennsylvania. So having looked at their application, they have a map specific to the Pennsylvania portions. Obviously, it's a bit small here, and but when you go to the application, you can take a deeper look at it if you can. But the line will extend, again, about 10.7 miles in total within Pennsylvania. It's going to start at an existing 502 junction substation owned by First Energy in Dunkard Township, Greene County. And then it'll extend for approximately 2.7 miles to the West Virginia border. Once it's in West Virginia, it will extend 3.1 miles. And then it will re-enter Pennsylvania in Greene County, and then it will traverse through Greene and Fayette counties for about 8 miles before it proceeds back into West Virginia. So it's kind of like an in and out. As part of these PA portions of the Marl project, there's a description in the application as to the structures that will be involved. So they have claimed that they will require the installation of approximately 44 structures with an average height of 145 feet. Some taller structures may be used in certain locations, they said, to maintain appropriate clearances for certain structures and existing utility facilities. And the spans between the structures will be approximately 1,258 feet. It will largely consist of steel lattice towers, something like what's pictured here in this picture. This picture is just an example picture. It is not a picture of the facilities. And it will be a single circuit 500 kV transmission line. So as part of going about trying to obtain right-of-way, even though they're not a public utility, they can still send out land agents to try to acquire it through the voluntary agreement of landowners. And I understand that NEET MA has already been doing that. So they must, in doing that, they must, according to PUC regulations, have a code of conduct for its land agents. And in its application, the siting application specifically, Exhibit SP3, they did lay out their code of conduct for the land agents. I also found the web link, which is available here. And this is an example of what you'll see when you click on that link. So, you know, as landowners or tenants or occupants, you know, if land agents are coming onto the land to seek the landowner's voluntary agreement to right away, you know, you can check this code of conduct to ensure everything is being done in accordance with that. So let's talk about your options to participate in these application proceedings before the PUC. 4 different buckets here. We're going to talk about becoming a party to the proceeding by either filing a protest or a petition to intervene. We're going to talk about your options, like to just submit an informal written objection letter or comment without becoming a party. We're going to talk about testifying at a public input hearing, again, without becoming a party to the case. And also, you know, the right to, or the ability to request, not a right, sorry, the ability to request a property visit or a site view along the route. So let's talk first about how to become a party to the case. So you can do this by filing either a protest or a petition to intervene. A protest is a formal pleading that states your objections and concerns to the applications, and it will make you an active party of record. And as an active party of record, you will receive service of all discovery, testimony, motions, and other legal documents. And likewise, you must serve on all parties when you file a document. So this link is great because it provides instructions for filing a protest. The OCA did put some effort in to create a sample protest should anyone be, you know, of interest to avail themselves. It's available on our website. While this is the first page of the protest, there is an instruction page that precedes it that explains how to do an e-filing with the commission, and if you can't do that, then how to paper file it. But there are fill in the blanks to help any pro se individual, you know, navigate their way to filing a protest. Okay, and what about petition to intervene? This is where you're requesting to become a party to a case and showing a direct interest in the case, but there are limitations as compared to being a protestant. So the limitation is in participating in hearings. So the regulations, the procedural regulations say if there are 2 or more interveners having substantially like interests and positions, the PUC or the ALJ to expedite the hearing can arrange appropriate limitations on the number of attorneys who will be permitted to cross-examine, make and argue motions, and even object on behalf of the interveners. But like being a protestant, it will make you a party to the case, and it will depend on the ALJ whether or not you can select to be an active party or an inactive party. There's no guarantee to this, but If the ALJ allows it, that means as an inactive party, you won't be served with all of the documents. But if you do make a filing yourself, you will have to serve all of the parties. Like the protest, we have a sample petition to intervene on our website. Again, here's the link. And there is an instruction page that proceeds. And again, it's fill in the blank to help you navigate potentially filing a petition to intervene. Okay, so let's talk about your non-party options. So there are two significant ones. So one is you can file an informal objection letter and or comments. This will not make you a party to the case, but it will put your concerns, your objections to the applications, you know, in the dockets for consideration by the other parties and potentially for consideration by the ALJs. So the suggestion is you know, you just write an informal letter or objections, but you should have the docket numbers and the case numbers, and you should mail it to the PUC secretary, and the address is provided here. Now, a really great way to be heard is if you don't want to be a party to the case is by participating in the public input hearings. Now, if you choose to be an active party to the case, or inactive party, so if you choose to be a party to the case as a protestant or a petitioner, an intervener, you cannot testify at the public input hearings. Instead, as a party to the proceeding, you are expected to participate in the formal process before the ALJ and in the evidentiary hearing process. And this can be hard, I think, sometimes for pro se individuals, because when we submit testimony in the evidentiary hearing, it's usually in the form of written testimony of expert witnesses, as opposed to lay witness testimony. Most individuals are probably going to be a lay witness. So you can be heard and testify on the record by just participating in this public input hearing. And the OCA puts great effort in trying to amplify those voices through our testimony ourselves by summarizing it by issue or submitting it in briefs. So while it's available in a transcript, we also try to amplify the voices that we've heard during the public input hearings. But the reason why you can only do one or the other is that it avoids a party getting what is considered an unfair 2 bites at the apple, right? So you either get to testify as a lay witness at public input hearing, or you can participate in the evidentiary hearing process and submit written testimony of an expert witness. So with public input hearings, the PUC will set the date, times, and locations. They'll publish it in a notice. The OCA will also publish it to, you know, on our social media. And there's usually an in-person and virtual options, although that cannot be guaranteed, but that's typically what the PUC will do. And the OCA will request that public input hearings be scheduled in these cases. So when you're at the public input hearings, you have options that you can either testify under oath, and again, your statement becomes part of the record, or you can make an unsworn statement. Members of the public can simply sit in and listen as well. Let's talk about sworn testimony option. So if you decide to testify under oath, what will happen is the ALJ will call you and administer an oath, which means swearing you in. You're promising to tell the truth. Then you will start your oral testimony. After you conclude your oral testimony, lawyers for the parties and the ALJ are permitted to ask you questions about your testimony. And that all of that testimony, your oral statement, plus the Q&A that followed, will be transcribed by a court reporter and will become part of the evidentiary record. Now, if you come prepared, you know, you have to walk up to the mic and you have a statement written, great, you're allowed to read that into the record. If you have documents that you think are supportive of what you're saying and would you like them to be admitted into the record as exhibits to your testimony, that can be done. And the OCA, as attorneys there, are there to support that process to ensure your exhibits get into the record. But I can say it's been my experience, the ALJs are also very friendly in this regard and try to make that process easy for consumers and members of the public. So once your testimony is in the record, parties to the proceeding like the OCA, we can rely on in that to support our positions and arguments in the case because it is sworn testimony in the record. So let's talk about the second option when you're at the public input hearing, and that is you want to provide an unsworn statement. So if you decide to do that, the ALJ will call you to speak, but that person will not swear you in. You will begin your statement. After you conclude, the lawyers for the parties cannot ask you questions, and your statement will not be made part of the evidentiary record. And then because it's not part of the record, parties in the case cannot rely on it, right, in support of their position and arguments in the case. But, you know, if you wanted to be heard, you know, otherwise, without it being transcribed, that would be your opportunity to do so. So issues that have been raised in testimony at public input hearings, especially in transmission line cases, have included in the past issues such as the cost and need for the project, safety and health concerns, effects on the environment, effects on the community, and effects on individual property. And while these are examples of what's relevant, individuals, people who are testifying can raise any issue that is relevant to the applications. So what can you expect at a public input hearing? Again, the ALJs or the administrative law judges, they preside over it. They place a sign-up sheet. If it's in person, they place a sign-up sheet at the door. If it's telephonic, they'll typically request or require individuals to sign up in advance so they know who's calling in. They'll call the hearing to order. They'll put a summary. They'll state a summary of the proceedings, and then they'll allow counsel for each party to introduce themselves and what their positions are in the case. And as I explained, members of the public can simply just sit there and listen. You don't have to testify or provide an unsworn statement. Once, though, every witness who wanted to speak has had the chance to speak, the ALJ will adjourn the hearing. And a few days later, the lawyers all receive copies of the transcript. And that transcript is also placed in the formal PUC file. Just to note, members of the press are permitted to attend public input hearings, but are there limitations to that? Yes, the ALJs can impose limitations, and individuals can also can express their desire to control information about themselves and the dissemination of it. So if you object, you should to being videotaped or photographed or recorded by a reporter, you should let the ALJ know that, and the ALJ may make instructions for the reporter to turn off equipment during that person's testimony. But that wouldn't mean the transcriber would stop. It would still be part of the record. So the fourth way of participating in these proceedings is through property visits, site views. So either parties to the case, affected landowners, and state legislators can request that there be property visits along the proposed route or alternative routes. These requests for there to be views of the sites are treated similarly to public input hearings by the ALJs, or at least they have in the past. And it is really up to the ALJs or the PUC's discretion and decision to schedule these if substantial public interest has shown that there is a need for them. So the things you can expect is that these are kind of conducted in the same way as a public input hearing, in that there will be a court reporter, there may be a PUC photographer, and what will be going along the route, and all the lawyers of the parties will be present and will literally go along the route and hear from the affected landowners as to how the cited proposed project will affect their interest. So during that time, the ALJs and council may ask questions regarding, what the landowners are, or affected, those with affected property interests may be bringing to the attention on the record to the ALJ. Usually, though, documents and exhibits will not be accepted during site views, but I think that is completely up to the ALJ. Okay, so just to recap, we talked about if you can become a formal party by filing a protest or petition to intervene. You could choose not to become a party, and you can file written objections or comments, or you can testify at a public input hearing. And as a party or affected person with affected property interests, you can request site visits. Okay, so if you decide to become a party to the application proceedings, I'm going to give a brief overview of the PUC process. So you did see this slide at the beginning of my presentation, and I talked about it a little more high level, but I'm just going to go through it a little more in detail. So the PUC process in something like this gets started by the applicant filing the applications. So here it is NEAT MA that filed the 2 applications. That is what has started everything off. They are asking for authority and approval from the PUC. And in doing that, they must show certain things that are required by statute and regulation. So those applications have been filed. Now, while this slide is generic, as I mentioned before, NEAT MA is not currently a public utility, but it is asking to become one. So once the applications are filed, then there's a response, right? So the PUC has received that, published it, and said, if you want to respond to this, you have to do so by May 1st, 2026, and you have to file a protest or petition to intervene. So that's the response period. And what our office does is we review the application, and if the consumer advocate determines that issues are present are impacting the interests of utility consumers, the OCA will file a protest before the PUC. So likewise, consumers, pro se individuals, other interested parties can file pleading before the commission to become a party. Again, a protest or petition to intervene. Okay, once that happens, there's process, and it's going to move through the PUC's litigation process before a judge. Okay, and that judge is called an administrative law judge or an ALJ, and is the ALJ that proceeds over the litigation process. So there's going to be, and I'm going to go to my next slide here to show a bit of what they're going to do here. So this first rectangle here on the left, the ALJ will hold a pre-hearing conference and decide preliminary matters such as modifications to discovery schedules and what the procedural schedule will look like, whether there's going to be public input hearings, whether there's going to be site visits. Okay, after that, the parties all kind of know, all right, how much time they have and when the deadlines are. And the parties can then begin, we move to the second rectangle, we move to the discovery phase, where the parties issue various different forms of discovery, usually in the forms of written interrogatories, seeking information that may be relevant and may be able to be admitted as evidence into the record. Kind of concurrent with that is at some point there will be a public input hearing scheduled, and if property visits are scheduled, those will occur as well. And that's where we're taking the sworn testimony of, affected members of the public or concerned members of the public. Then there will be a time period for written expert witness testimony to be exchanged. There's usually several rounds of that. Again, there can be motions during that time. And then we move into the evidentiary hearing. And this is where the judge convenes an evidentiary hearing where all the parties represented by counsel or pro se individuals participate. And that is where evidence gets moved into and hopefully admitted into the record, subject to cross-examination. And that's when cross-examination takes place. And following the conclusion of that evidentiary hearing, there's a period where the parties submit legal briefs. So a main brief and a reply brief, making their legal know if there's any relation between the two projects. But the way I've seen this application and then the announcement of that project, it would seem separate, but I don't know if there's any relation between them.
I appreciate it. And
meaning I don't know if they're planning to site a generation power plant near these lines at all. I don't know that.
I think based on, their request to get standing as a public utility, that if they were related, they would have been very specific in their application. So, yeah.
Well, not necessarily. And here's why. So their request to become a public utility is narrow, limited to transmission facilities, and these particular transmission facilities within Greene and Fayette County. So public utilities currently separate, but I don't know if there's any relation between them. Do not own or operate generation plants, right? So NextEra has multiple entities and subsidiaries through which it structures its various business dealings, and so this generation plant that you're referring to may not be the same entity that is applied for public utility status. And but so that's why it wouldn't these applications wouldn't necessarily reveal that. But all I'm trying to say is I'm not sure if the generation plant will be sited near these transmission facilities at all.
Okay, thank you. And I'm gonna back off and let Jake then moderate some of the other questions. Thank you.
Sure. Yeah.
Yeah. We have a couple. One from the group in the district. So their question is that everybody at the meeting isn't sure of the exact route and is having trouble finding a clear, accurate map. So they went to the Point Marion Library and try to take some pictures, but everybody here doesn't know if they're directly affected or not. So they were just hoping for some clarity.
Also important to this is section 57.75, and it talks about the type of evidence that the commission will receive, especially subsection E, and it can look at things such as the present and future necessity of the line, the safety of the proposed line, the impacts and efforts which have been made to minimize the impact upon the following, and relates to the environment such as land use, soil and sedimentation, plant and wildlife habitats, terrain, and the list goes on. And it also says they will take evidence of the availability of reasonable alternative routes. So, as I mentioned in the application, they have their preferred route that is the proposed route and alternative routes that address these types of factors. And then in the commission's regulations, the policy statement at 52 PA Code section 69.3106, they require that there's a matrix, that the applicant have a matrix or a list showing all expected federal, state, and local government regulatory permitting and licensing approvals that are required for the projects. And moving on to 69.3107, it talks about health and safety considerations, including the use of herbicides and pesticides for maintaining the transmission line, and an examination of electromagnetic field impacts. So the applicant applicant is supposed to include a description of EMF mitigation procedures that the utility proposes to utilize along the route. So these are the things that the commission can and will consider.
Thank you for that. So Beth Ann, thank you for dropping that link to the online map in the chat on Teams. Becky, for all the folks at the fire department, I put that link in the chat over on Facebook. So hopefully you guys have access to that now. Another follow-up question from Beth Ann about the mapping. Neat MA Online's map feature in May of 2025 allowed users to view houses and structures and zoom in. In September 2025, when they announced their preferred routes, their website no longer had that feature. Still today, according to her, NextEra's website still does not provide an accurate or reliable way for the public to zoom in and view impacted land parcels, preventing landowners from independently confirming whether they may be affected. Together, these deficiencies reflect selective outreach and insufficient transparency for a project of this scale. If their website had that capability in May of 2025, why wouldn't it be available today? And she's saying it would make it much easier for landowners to make determinations.
I understood from the company myself that there was an interactive map. I haven't checked it recently, so I'll take your word for it that it is no longer available. But I do believe, and as I said, subject to check, that all parcels that are along the proposed routes, right, should receive notice. There's also the general publication of these applications in the Pennsylvania Bulletin, which from a legal notice standpoint is considered to meet the commission's notice obligations to the public. So that has been met. So, you know, to the extent you might be affected with rights of way, I assume you would receive specific notice and communication from the company. I just don't know at what stage in the process. So that is a takeaway for me. As for the map, again, subject to check, I believe that there is a map plus a list of affected properties. So I will check that.
Thank you for that. Hannah has a question for you. Given previously documented allegations that NextEra used nonprofits to influence projects and elections, can you confirm whether you are aware of any organizations advocating for the Marl project are directly or indirectly funded by NextEra or its affiliates?
I do not have knowledge of that.
Okay, question from Christine. So if they proceed with the proposed route, the alternate routes will always be open for a transmission line at a later date. So that was a question, not a comment.
Can you repeat that?
Yeah, so she's asking whether the alternate routes would be open for a transmission line at a later date. Could the I guess she's saying if there was an alternate route proposed, would there always be the potential that a power line could come through that alternate route?
I'm going to restate what I think the question is, which is if a route is approved in these applications, let's say there's the preferred route 1, route 2, and route 3 are the alternatives, right? Let's say the applications go through and the PUC approves route 1. Because route 2 was considered, does that mean a line can just come through there without this whole process starting again? The answer is no.
I think that's what she was going for. Questions from the fire department. Says the constituents here are concerned about not knowing which forms to fill out because they do not know who is directly affected. They asked for a specific website that people can go to be able to view this information with a more clear map. Becky, that is hopefully that link that I dropped in the comments. Hopefully that will help with a little bit more clear of a picture. Another question from the fire department from Judy. She's asking, can the company become a Pennsylvania public utility if they do not provide any electric power to the residents of Pennsylvania, but only transferring it to another state? If they're not supplying residents of Pennsylvania, can they become a Pennsylvania public utility?
That is, I think, a question that will be considered in the application, and a part of, whether or not they meet the definition of public utility under section 102, and whether or not they meet the standard of 1103, that it's necessary or proper for the safety or public of the convenience. So the question is, that the ultimate consumers to be served may not be Pennsylvanians only, but others as well out of the state. Can that be considered? So that will be something that I think the commission will have to determine in this proceeding.
Another question from the fire department: is there a list of residents that might be affected? Because everything they're seeing in the map is terminating at Bunker Hill.
When someone asks me a list of residents that can be affected, are we talking about right away on that resident's property, or just otherwise affected? Because I just want to understand the question.
Yeah, I without having to wait for clarification, let's just say it would be directly affected via property.
Mm-hmm. Through rights of way. So then, I'm sorry, after my clarifying question, I can't remember the original question.
Basically, just asking whether there's a list of affected residents rather than having to rely on that map.
Yeah, I believe there is in the application. Like I said, I was just reviewing it over this weekend. So that's subject to check, and I will get back to the representatives' offices with that to confirm. And I'll even point out which exhibit it is. And if it's not there, I'll make it clear that it's not there.
Okay. Another question from the fire department. They're asking what's producing the power. Is it hydro? Is it gas? Is it solar? That this transmission line is going to be carrying, basically.
So this goes back to my slides about PJM, and these lines are not necessarily going to be carrying power from a specific generation plant as a source to a specific endpoint. They are projects that are there to address reliability needs of the overall transmission grid, and as such, power from all those different sources will be traversing over these lines potentially.
Another question from the fire department. With the history of eminent domain in pennies on the dollar, would it be beneficial for the residents to get their properties assessed at current value so they know what their property is valued at if that were to become a concern down the line?
So one of the slides we removed, but maybe we should keep in there, is we do not practice eminent domain law. So what I can tell you as it relates to PUC practice is that before a public utility may exercise its power of eminent domain, so let's say NEAT MA gets its certificate of public convenience and becomes a public utility, it must file another CPC for approval from the PUC. Okay, and where there is already a certificated utility making a siting application, oftentimes they'll make this eminent domain application at the same time and have them consolidated with the siting application. But because NEAT MA is not a public utility right now, it does not have this eminent domain CPC application before the PUC at this time, because it's got to go step by step, right? So that is the extent of our office's involvement in eminent domain as it relates to the PUC's proceedings. We do have, let me pull you up a slide so I can refer you to some other provisions of the public utility code, public utility regulations that relate to eminent domain, and that's 52 PA Code 5791. But, you know, relating to your property interests, you know, you may want to seek out, you know, either, you know, the advice of a private attorney with respect to eminent domain.
Okay, question from Susan. She's asking whether people can file complaints or protests online, or whether everything has to be written on paper and mailed.
Yes, there is e-filing at the PUC, which is a wonderful feature because that helps reduce the amount of paper we all have to deal with, which is very helpful. And so if you go to our website, which had the sample protest and petition to intervene, so let me get that. We explain how to e-file something. I'm just going to see if this works. You're going to see all my various tabs. I always have lots of different things open. One moment. So here, if you go to our website, all of the different files relating to the initial files of this application are available for ease of convenience and review on our website. But like if you pull up the sample protest, it becomes a download and it explains to you how to e-file. So the instructions for a PUC, you have to do a PUC e-filing account and you have to agree to e-service. And then from there, it can make service much easier because you know, most of the parties will agree to email service as opposed to having to do everything in paper. And so we provide you links on how to create a PUC e-filing account. And it is, once you're up and running, it's relatively easy and convenient to use. But if you wanted to do things by paper, we also explained to you where to send it, and you're supposed to send it by overnight delivery because there's something with the mail system over there, and so they caution you on the PUC's website to retain your tracking information as proof of submission.
Beth Ann's asking, is there any way for all PJM states to have a minimum generation capacity level, so states like Pennsylvania with excess power are not impacted by states without adequate power?
Yes, that's a great question. And our region does have, PJM does have a resource adequacy requirement, but as you note, some states are greater producers of generation than other states, and regulating the development of generation is a state's right. So states can have more say when it comes to our generation resources and mix. But you know, in the moment, you know, we're all part of this wholesale electricity grid, and our utilities are not vertically integrated anymore. So there is an overall region-wide resource adequacy requirement, and that is enforced through market forces. And but it doesn't really stop. I think the example that was just given, where some states may be producers and that power has to flow to some states that have higher load, but maybe that doesn't have the generation to meet it. And right now, that's a really big issue, given the influx of data centers into the region. And so it's a good question, but it is right now met through a region-wide resource adequacy target that gets met through market forces such as capacity markets.
Beth Ann's also asking whether Pennsylvania and West Virginia could leave PJM and make their own RTO to boost our own economies.
Well, right now, there is no state law that says Pennsylvania must be a part of PJM. And instead, our transmission owning utilities are voluntary members of PJM. And I probably should have kept a history slide here. I mean, PJM is a really long history, going back to, early 1900s, where transmission utilities were voluntarily engaging in a power pool to meet their needs. And that's its origin, and it evolved over time to become a more formal RTO structure that it is today, and as large as it is today. There are benefits and there are challenges to, being within an RTO. So certainly policymakers can consider the question you posed.
Another one from Beth Ann. Alternate routes have not received any certified mail from NextEra for this application to the PUC. Is there a process to request that be done?
Okay, I'm sorry, can you repeat that again?
Yeah, she's saying alternate routes have not received any certified mail from NextEra for this application, and is asking if there's a process to request that to be done. I guess the first question is, are alternate routes even proposed yet, or would that come at a later time?
Yes, alternate routes are in the application, the siting application. I did say that I am not certain what the notice obligation is for the property along the alternative routes, although I would suspect they would have to be noticed in any way that those along the preferred route would have to be. So also, I just want to say that there's a blanket right now public notice obligation met by the PUC through its publication of the applications in the Pennsylvania Bulletin this past weekend. So, but I will go again to check if there's that exhibitive list of affected properties and get back to the representatives, because I think that will help with these types of questions.
Looks like Representative Krupa wants to chime in. Go ahead.
Just wanted some clarification, and I think one of the questions earlier hit on this in terms of standing. So I would think it would be very obvious that if you have land that the proposed route or an alternate route, that you definitely have standing to be a party. If your land is not directly impacted, but you might be the adjoining property, what specifically gives you standing to be a party, and not just somebody that's submitting comments or at a public hearing?
Sure. I think that person could demonstrate, and it could be adjacent or doesn't even have to be immediately adjacent, because that person may have concerns over environmental impacts to ensure that all requirements are being met, or health and safety considerations. I know that others have been granted where the right of way is not coming through their land, but it's affecting their, for example, the beauty of the view, for example. So just things of this nature. So any way that the line affects you, if you can show there's you're being affected through environment, whether it be through views, other types of environmental concerns, or health and safety considerations.
And just to be crystal clear too, because I think a lot of the people, when we did the previous town hall, and I think it was just last week, thanks to you, that pointed out that there's two very different applications. So I'm assuming that the standing for the siting application, which is the actual Mara project, is completely different than standing to object to NextEra Energy being recognized as a public utility. I would think that the standing, and maybe you can clarify for us, please, standing for their to object to NextEra Energy being considered a public utility, I would think anybody in Pennsylvania would have standing to intervene and become a party in that application.
Anyone in Pennsylvania would, you're saying in the CPC application, right?
CPC, yeah, that's someone to be recognized, for them to be recognized as a public utility, correct?
Yes,
Yeah.
yes, correct. So the public utility application, we'll call it. Very good.
Okay,
And then we'll call
thank
it the
you.
siting application. Good.
Thank
So,
you.
these questions on standing are, legal conclusions. So I do want to be careful and not, making legal conclusions because they're for the PUC to make. And I want to try to avoid giving, legal advice. But with that said, with those disclaimers said, what I would like to say is we see these applications as related, as involving related questions of law and fact. So we are, considering, we haven't made any filing yet, but it's potential that these applications could be consolidated. So if there is a consolidation, any party with a standing in the citing will have that same standing in the CPC and vice versa. Now, if there is not a consolidation of these applications, but, like I said, we think there are common questions of law and fact here, then yes, as for the citing, I think it's probably going to be very similar that they're going to look at the question. I could be wrong, but so again, it obviously landowners with rights of way on their property, right? But even adjacent or nearby, right? If they have environmental or health and safety concerns, they can be in. And then even wider, to your point about the public utility application, yes, an even wider, expansive grab of who can come in. Mm-hmm.
And I think the question earlier about, if they're not actually benefiting Pennsylvania residents, why should they be considered a public utility? And I think that would be a really good argument. Again, I'll just speak for myself, because although I am an attorney, I'm not have no experience in this particular issue. But I think that any Pennsylvania should be able to raise the argument of, what? You're not benefiting Pennsylvania. You're going to make our grid supply even worse. Therefore, you should not be granted status based on that hoax that you're actually serving Pennsylvania. But that, I'm just saying that on my own personal remarks, and I understand that you can't give legal advice. Mm-hmm. Thank you for that response.
Mm-hmm.
Got a couple more questions from the fire department. One person's asking if you could provide details about the terms of lifetime of the project in which property owners can be informed to determine how much and how long property owners will receive monetary compensation for the use of their property. Secondly, what funds will the county receive, and can your office make recommendations for the county to direct funds to the community's school districts?
I might have to take the second question again. I'm sorry, that threw me a little bit. But the first one, as to who's affected, again, I'm going to double check to see if there's that exhibit of the list of properties. But as for compensation, this gets to two issues relating to property law, right? First is whether or not you want to enter into voluntary negotiations with NEET MA, and come to a voluntary agreement relating to our right of way, which would involve compensation based on the terms of that agreement, which my understanding can be either a one-time payment or something that gets revisited should there be other terms. So I cannot give advice that this would be what a real estate or property lawyer would give. And then the second is, if you do not agree to a voluntary agreement with the NEET MA and NEET MA were to obtain public utility status, it could then proceed to eminent domain proceedings, and then there will be an eminent domain compensation according to the eminent domain law.
The second part of that question was they were asking what funds will the county receive, and whether your office could make a recommendation for the county to direct those funds to the community's school districts.
Well, to the extent the county is to receive funds, it would be because it would be on county property, right? So, and then that would again, as opposed to privately owned property, right? So county-owned property. So the first part of my answer applies. Again, it gets to whether or not the county wants to voluntarily come to an agreement on the rights of way with NEAT MA, which will govern compensation, or it can proceed to eminent domain should NEAT MA obtain public utility status. And on that second part about then direct what the county would do with those funds, no, our office would not be able to make a recommendation on that. It goes beyond the bounds of our enabling statute.
So another question, they're asking if they're able to stop the eminent domain. Does that stop it from any other route in Pennsylvania? I think by eminent domain, I think she just means the actual proposal itself, the transmission line in effect. So if they were to determine it wasn't eligible for this plan, would that stop it altogether?
Right. So if the siting application were to be rejected, right? So if the siting application on a proposed route or an alternative route, or as modified during the proceeding gets rejected, then yes, it would not, it wouldn't seem like there would be anything to file an eminent domain proceeding on. So they do need the siting application approval, correct?
Another resident is concerned because according to the map, the route is showing that it looks like it's going right through his property, but he hasn't received any type of letter or notification from the company. So he's asking when they are required to send out that notification, and should he have received that already?
So I'm trying to see if I can do a quick scan of the regs real quick to help me, because I know this is a question that's keep coming up, and I said I have to check it. Let me just see real quick.
While you're looking that up, I want to address Dave Beal's question, who asked how this is going to benefit Pennsylvania and landowners affected by this proposal.
If I
Dave,
could,
go ahead.
yeah, real quick. I do, and I don't want to get lost here. So if you go to 57.74, so 52 PA code 5774 talks about filing and service of the application and notice of the filing. Subsection C says, at the time of filing, the applicant shall serve a filing and a map of suitable detail showing the proposed route of the proposed facility by registered or certified mail, return receipt requested upon the following. So there are a number of officials, and then when it comes down to affected property owners, it says for the persons, corporations, and other entities designated in, and it makes a reference to 5272C4. So going to 5272C4, it must be served upon the names and addresses of known persons, corporations, and other entities of record owning property within the proposed right-of-way, together with an indication of HV line rights of way acquired by the applicant. So that says the proposed right-of-way, and I think the question is if they're on alternative routes, does that apply to them as well? So again, it just seems the answer should be yes, but I will confirm that.
Got it. I did want to address Dave Beal's question. He asked how this is going to benefit Pennsylvania and landowners affected by the proposal. Melanie addressed that earlier. I think the PUC just kind of has to determine that as to whether it does benefit Pennsylvanians in any way, and they're going to weigh that question in their process. One last question we got from the fire department is why can't they use existing power lines in the area now rather than building a new one through untouched land?
Yes, I think that is always the main question is, why can't they use existing right away? Why are they, having to use greenfield, right? Or new right away, right? Land that doesn't have right away on it currently. And I think the answer here is because NEAT MA is not a public utility currently within the Commonwealth and probably doesn't have much right away for transmission facilities within the Commonwealth as a result. I'm not saying it doesn't have any, but it probably doesn't have, as much as your incumbent transmission owner utilities such as PPL, PICO, for example. So with that, this NEAT MA, like I explained to the PJM process, submitted this transmission solution, this MARL project, and it was selected by PJM. And PJM, I think as part of that process, does look at the risks or the probabilities of the proposed transmission lines being built. And they look at things such as the fact if it's on existing right of way or will be on new right of way. But that's the extent of their analysis of that. They will only look at, is this constructible? Meaning, is it high risk, low risk, medium risk with respect to the land rights that the transmission owner must secure? They don't weight it either way, meaning that the project is better or worse because it's using existing or proposing for new land. So PJM, knowing that there was going to be new rights of way to be obtained here, still selected this project to solve the reliability needs of the region.
And so it's kind of a question along those same lines. Teresa's asking, would the PUC look at alternative technologies like underground HVDC in existing easements or along highways? I don't know if that is the same answer, if it'd be a little different.
Yes, so the PUC can look at those things for sure. And so the answer in short is yes. With respect to undergrounding, consumer advocate Daryl Lawrence has spoken in favor of undergrounding in many different forums. The problem though with high voltage transmission lines is that it can be very costly. So, and only certain kinds of lines are even eligible for undergrounding. But with respect to being in public rights of way, yes, that they can look at that for sure.
Representative Krupa, I think I'm all caught up on the questions. So if there was anything you wanted to maybe close out with.
Thank you, Jake, and thank you, Mel, for you've been in the hot seat for an hour and a half, and I really appreciate you taking the time and everything that your office has been doing. I do, just to confirm, the Office of Consumer Advocate is planning on becoming a party to this proceeding and filing a protest. Is that correct?
That's correct.
Okay. So I want to thank you. I look forward to, and I'm going to follow up just so the participants are aware. I'm going to follow up with your office in terms of the timing of how my office can request the local public input hearing. So I don't want to take up the time here now for that, but and we're going to make this slideshow and presentation being live streamed now, but we're going to make sure that it gets put up on our website and that it's available on our Facebook page. And then as we work with the Office of Consumer Advocate to get answers to some of those questions, and no, these are concerning issues, and although the wheels of government take forever sometimes, it seems like I made a list of possible bill ideas here. If there's any gray area or loophole at all that the alternative route landowners don't have to be notified, I personally think that that is a violation of your constitutional due process rights, and will propose a bill to address that. That's not going to help us now. So hopefully Mel comes back and says, yeah, you have to have that notice, and we'll go from there. But I just want to thank everybody involved, all the staff for staying late, Mel for your wonderful presentation, and everybody that's asked really good, meaningful questions, and everybody that's logged in. Thank you all. Rep Cook?
Mel, Jay, I want to say ditto to everything that Representative just said. We couldn't have made this possible without your help and assistance. And then also all the people that joined in this evening. We really appreciate your questions. We'll part on this end in Harrisburg to try to keep an eye on it. And Representative Charity, thank you so much for taking the lead in this.
And Representative Krupa, if it would help, I think I have the big glaring questions about notice on alternative routes, and if there's a list of affected properties in the application. So what I can do is update this presentation before you post it with a Q&A on the end that addresses that. And then that way, folks, when they refer to this, they can refer to that answer as well.
Oh, that's awesome. And Christine Tarsi had asked that question. So Christine, if you're still listening, then on the updated slideshow, we'll have those answers available for the public. Thank you.
Absolutely. Thank you, everyone. I hope this was informative. I appreciate all the great questions. I think everyone came in here really well prepared. I'm honored to have time with you all, and thank you very much. And I hope I can get answers to these right away and update the PowerPoint and get it over to the representatives soon. So
thank you so much. I'm gonna exit out here. I'll be the first. Bye. Thank you, Mel.
Thanks, Melanie.
Thank you.
Yep.
We
All right.
appreciate you. Take care, everyone.
Thank you, everybody. Bye.
Bye-bye.